Joe Biden had 82,000 emails, which is even more emails than Hillary. And we know how much the media didn't care about Hillary's emails, so we'll see if they care about Joe's. But we do. We're curious what's inside those 82,000 emails. And we know that Joe Biden was using a bunch of different email addresses. We'll review what those were. But this comes out of a FOIA request, a Freedom of Information Act request. And we actually have the actual litigation pulled up. We'll go through it and see what popped out of this, which is a lawsuit from a private party to the National Archives. And then they revealed what they have that they have not produced or they're working on. And so we'll see exactly what's going on there. But before we get into it, let's take a look at some background here. This comes over from Just the News. They tell us that under legal pressure, the FOIA lawsuit that we'll review, the National Archives has located, check this out, 82,000 pages of emails that President Biden, Joe Biden, sent or received during his vice presidential tenure on 3 private pseudonym accounts, fake names, a total that even potentially dwarfs the amount that landed Hillary Clinton in hot water a decade ago. That's according to a federal court filing that we're going to read. The total of Biden private email exchanges was disclosed on Monday in a little notice status report from this lawsuit. There was a Freedom of Information Act lawsuit brought by the Southeastern Legal Foundation, shout out to them, against the National Archives for not complying with the FOIA request. There are rules that say that you're allowed access to information. They requested it. Archives says, no, you can't have that. They sue to say, yes, we can. And then they're providing joint status updates to the court to explain what the litigation is, what the status is. So the foundation that brought the lawsuit, seeking access to emails, is going after 3 pseudonym email accounts that are listed as the following. And they're very strange, right? robinware456@gmail.com is one address. And so like using Gmail servers for who knows what. Business, I don't know. Are there classified documents in there, right? They're hemming and hawing and screaming about Trump's classified documents. But there's 80,000 potentially in a Gmail account somewhere on some Google server bouncing around the cloud. Wild. JRBware, also a Gmail account. JRBware, a Gmail account. And then finally, this one, which we reviewed, and we had some very great analysis come in on this that we'll probably have to dive into at some point, but about this PCI.gov address, which is a government account. It is a government domain. And they set up a pseudonym called Robert.L.Peters, Robert L. Peters, which is another pseudonym for Joe Biden. But the question on this one, okay, anybody can go set up a Gmail account, create whatever name you want, and nobody verifies that. But if somebody's going to be setting up a government account on a .gov, don't you need some sort of like administrator privileges to do that? Can anybody just create a pseudonym? Hey, Senator Joe just wants a fake government email account. Oh, sure, we're in the business of fake government emails. Let me send you over to IT. They'll draft that right up for you. Because that's why we use government emails, so that you can chronicle and catalog everything for public records requests like this one. So this was not private either. This was during the time that he served as Obama's vice president. Why would you need those 3 pseudonyms? The status report filed on Monday was the first to provide the estimate of the size and the scope of the possible contents over 82,000 pages, which we'll see. But the court added that the foundation and NARA are discussing ways to narrow the request for the records and to get copies of the emails in a more expeditious manner. Now, we know government officials and their use of private emails for official business is discouraged under the law. And officials like Biden are required to preserve all government-related emails conducted on their private accounts under the Federal Records Act. And we can't know if there's classified documents or top secret materials or any of the other nuclear codes or enemy strategy plans that they say that they allegedly found in Trump's boxes. Now, the fact that NARA, and Joe Biden wasn't the president, mind you, never until recently. He was the vice president at the time. And so he didn't have the same authorities that the president has. Now, the fact that NARA has such a large collection suggests that Biden gave those emails to the nation's history preserving agency. Now, that's curious. Meaning, is there nothing in there? Are those Joe's spam email accounts? Every time he signs up on a new website, he goes, I think I might buy this product. Insert your email for 10% off. Joe Biden's like, oh, I hate these newsletters, man. And so he inserts his fake government email pseudonym. That's it. It's all benign, I'm sure. So the total revealed by the archives is stunning in size, even dwarfing the total from the most infamous private email scandal, my emails, involving Secretary of State Hillary Clinton, which was also government business on Obama's watch. Now, the State Department Inspector General report previously with Clinton said that Clinton improperly used a private email server stored in her family's home to regularly conduct government business and then later deleted the emails. Secretary Clinton and her email, okay, the State Department produced 55,000 hard copy pages representing more than 30,000 emails on her private servers. Now, those totals are significantly smaller than Joe Biden's personal account. You can read through the emails that Hillary was found with. The government recovered even Miss Clinton's personal emails and released them all under FOIA, totaling 52 82,000. But to date, there's no indication from the National Archives in the court case that any of Biden's emails contain classified info. Well, have they looked at them? Now, however, the president is under criminal investigation by Robert Hur for taking classified documents from his time. But does the scope include those 80,000, or does it just include what they found at the Penn Biden Center and Joe Biden's garage? From his time as vice president and as a senator and storing them improperly, there you go, in his garage and at a think tank at the Penn Biden Center. Hur recently spent 2 days at an interview with Biden that he didn't tell us about until after the fact. And then former President Trump has already been indicted by Jack Smith for his classified documents problem. And so it is very curious what's happening here. I mean, why do you need pseudonyms? And yeah, Hillary Clinton had a private email server like @clintonemail.com, but this is depending on your position on this, maybe arguably more secure or less secure, because Hillary had some, sounds like an idiot, set up her email server security, and that may be where a lot of the WikiLeaks stuff came from. Nobody knows, or maybe they do. But Joe was using a Gmail account, which certainly would be accessible to, I would imagine, a much broader swath of people within the Google organization. Now, I don't know what their accessibility levels are like, but I don't think they're classified for top secret classification documents. And the fact that he's using those servers, it doesn't exonerate him. He's using a non-government server. Hillary used a private server she just shoved in her basement, but he's using a commercial service in order to get it done. Either way, it's nefariousness. The intent is to hide the documents from the public eye. Now it's been discovered, and we should be able to see what is in every single one of those documents. So shout out to the Southeastern Legal Foundation, who has filed this suit, and this one is taking place in the Northern District of Georgia. And you can see here, this was filed updating October 30th, 2023. It is a joint preliminary report and a discovery plan to make these materials more accessible. So the Southeastern Legal Foundation suing the National Archives. And we've gone through other updates here before, but this one seems very substantive, and many of them are not, but this one is. They say, "Hello, Your Honor, we're just here with an update, giving you the status. This is an action under FOIA. We brought the lawsuit to compel the production of records related to our FOIA request dated from June of 2022, over a year ago, made to the National Archives. Now, in our request, we specifically sought copies of all emails in 3 separate email accounts purportedly being used by Joe Biden, the 3 that we just talked about. 2 Gmails, 1 at PCI.gov, during his time as vice president and preserved through NARA. Now, NARA has completed a search for potentially responsive documents and is currently processing those documents for the purpose of producing non-exempt portions of any responsive records on a monthly rolling basis. Now, given the scope of plaintiff's FOIA request, this is the people filing the suit, which seeks copies of all emails in the 3 separate accounts over an 8-year period, the volume of potentially responsive records is necessarily large. That's a lot of paper. NARA has identified approximately 82,000 pages, which is a lot, of potentially responsive documents, and it's currently processing those documents and preparing any non-exempt responsive documents for production on a rolling basis. In the meantime, the people filing the suit, they intend to propose, and the parties will discuss, options to narrow their requests in efforts to resolve this matter more expeditiously. We don't want the newsletter emails, okay? Take Joe Biden's or whatever he's signing up for over there. Nobody really wants to know. Take those emails out. Once the scope of the request is clarified through further discussions between the parties, and NARA has conducted a search for all the potentially responsive documents related to a more narrowed request, then we're going to discuss an attempt to reach an agreement at the rate of processing all of the potentially responsive documents and then producing the non-exempt portions back to them. So we're going to filter some of these things out. Now, these discussions may decide what we do next in litigation. Now, we agree, both parties, that no discovery is necessary at this time, and any disputes can be resolved at summary judgment. And so at this time, they say, please don't set an order for motions. Here's the basis for that. Both of them are agreeing, NARA and the other plaintiffs, say that these orders would be premature because right now we're still negotiating. We haven't hit a roadblock yet, and we're not sure that there's a problem with the rate of all the processing. NARA says that the full scope of the responsive records and any applicable exemptions for a dispositive briefing is not yet known. So NARA is even saying, we're still processing all this stuff, man. There might be more out there. They're still processing all potentially responsive records. And so the parties, therefore, request that the court instead issue an order requiring both sides to meet and confer and give another report just like this one by December 8th. So we'll come back. We'll see if they come back. Oh, we found 90,000. Oh, we found 110,000. And we're going to come back. We're going to give you another order. Judge is going to say, give us another update about the status of the negotiations over the narrowing of the request. What did you filter out? NARA's rates. How fast are they processing these materials? And a proposal for the next steps of the case. And they say, here's the proposed order. In the space below, they say here's what they're asking for. Or actually, they're just filling out a form for the court. It looks like they just grabbed a template, actually. Yeah. The joint preliminary report, right? They say, okay, here, just fill it out. Briefly describe the nature of this action. It's like a book report, right? And the judge just wants an update. Okay, summarize the facts of the case. They say, well, plaintiff wants all these records from these 3 emails. We know what they are. The legal issues are to be tried. Well, currently nothing. We're still negotiating. We think we can get it resolved amicably. The parties agree that the scope of the issues may be decided later at a summary judgment, but we don't know the scope yet because everybody's still processing. No pending related cases. This case is not complex. These are the lawyers assigned. Is there any question about this court's jurisdiction? No. No necessary parties who are not here. We're not saying anybody who is here should not be here. And the rest of this stuff is pretty much just simple. They're saying, hey, we've got filing times for motions, which will come at a later time when they're scheduled, initial disclosures, and I think a lot of this won't be relevant until they get further along. So all parties were informed. Counsel do intend to hold additional settlement conferences among themselves prior to the close of this, so we're still kind of in a pending status. The parties agree that a settlement discussion is premature because the scope of any plaintiff challenge to NARA's response cannot be known. The people filing the suit say, Your Honor, we don't really know what we're going to be upset about until they tell us no. They haven't told us no yet. We're processing. It's going to be a lot. If you helped us filter it, we would be able to get this a little done a little bit more quickly. But otherwise, they haven't gotten a no yet. When they get a no, then they will. So after NARA completes production, the case may become moot, right? Like it literally might be done if we don't challenge their response. If they say they gave us everything, okay. And if we don't want attorney's fees, no problem. So the case may be decided, and we'll consider that at a later time. And so, Your Honor, right now, we don't want this case tried before a magistrate judge, signed by both sides, Kimberly Herman, counsel for the plaintiff, and Kyla M. Snow, counsel for the defendant. Joint status report and a proposed order. They're saying, Judge, just basically make us come back here and do this again on December 8th, signed off by lay judge, district court in Georgia. And so another interesting filing, and my goodness, 80,000 plus Joe Biden emails stuffed off into various email addresses hidden away in Gmail and other literal government accounts. We'll see what the Southeastern Legal Foundation continues to uncover as we continue to cover this and more. Thank you for subscribing, my friends, and we'll look forward to seeing you on the next one.